Today's presentation is by Chancellor's Professor of Law, Michele Goodwin. Professor Goodwin joined the faculty of UCI Law in 2014, bringing expertise in bioethics, constitutional law, family law, health law, reproductive rights, and torts. She is the founding director of the Center for Biotechnology and Global Health at the law school. This center is one example of how Professor Goodwin helped to establish and shape the health law field, where she ranks among its most cited professors. As a constitutional law scholar, Professor Goodwin addresses legal questions related to freedom of speech, religious exercise, equal protection, due process, race and sex discrimination, reproductive rights, slavery, and LGBTQ equality. Her scholarship appears in or is forthcoming in law reviews across the nation, including Cornell, Fordham, Harvard, Michigan, New York University, Northwestern, and Yale, among others. Professor Goodwin is sought after as a public commentator and has been featured in print, radio, and television news. She hosts a very compelling podcast at Ms. Magazine titled On the Issues with Michele Goodwin. A prolific author, Professor Goodwin's publications include 6 books and over 100 articles, essays, chapters, and commentaries. Her most recent book, published last year, is Policing the Womb, Invisible Women and the Criminalization of Motherhood. In addition to her scholarship and commentary, Professor Goodwin serves on the executive committee and the national board of the American Civil Liberties Union. A leading voice in American law, Professor Goodwin is elected as a member of the American Law Institute, as well as an elected fellow of the American Bar Foundation and the Hastings Center. Professor Goodwin has received many, many awards. Most recently, she received the 2020-2021 Distinguished Senior Faculty Award for Research, the highest honor bestowed by the University of California on its faculty. We are very fortunate to have Professor Goodwin with us at UCI Law and on this evening to open our series with her remarks on civil liberties in a pandemic, the lessons of history. Professor Goodwin, welcome.
Thank you very much for that incredibly generous introduction. It's my pleasure to be with our community, which is near and also far, and to level set a conversation about the Biden-Harris administration, thinking about civil liberties and civil rights in time of health crisis, and we are in the midst of one. Over the past year, we have seen how COVID-19 has exposed underlying institutional and infrastructural inequalities in our society. Sadly, we've also seen the way in which it has produced vitriol and also hateful action as well. We have this talk at the end, the last day of Women's History Month for 2021. And it is in the wake of women being murdered in Atlanta, Georgia, who were AAPI, or from Asian American Pacific Islander communities. And we've seen that rise of hate, and we've seen it within the context of this pandemic. Just in the United States alone, there have been nearly 4,000 reported accounts of very vile attacks on members of our Asian American communities here in the United States. And so I want to acknowledge that in this talk, because it is actually a part of this talk. This is a talk about civil liberties and civil rights in time of pandemic, and it engages a historical backdrop. So let me begin there with this conversation. I'll also let you know that while the chat, I believe, is disabled, the Q&A function is enabled, and I will reserve time to take your questions. So in terms of doing some level setting, it's really important to understand that pandemic and health crisis has been a proxy for harming vulnerable communities. I mean, it's not new that infections exist, diseases that harm people, that can be communicable, and that can spread throughout communities. That's not unique to the United States, and this is a millennia-old problem in our global world. But what has been a feature of these United States, a very young country in many ways, has been the way in which race and racism has also played a role in how political entities and communities have addressed health crises. And for many of you, that may be surprising. And it's not just racism, but it's also socioeconomics. And so let me talk about what I mean there in terms of pandemic and health crises being used as a proxy for interfering with civil liberties. During the period of Jim Crow, many people will think about that as a time in which there was racial discrimination against African American communities. We've seen that in the photographic record and the video records of those times. We've seen that with Congressman John Lewis before he was a member of Congress, when he was barely no longer a teenager, organizing peacefully, walking, not even peacefully protesting, but peacefully walking across a bridge so that people could get to a space of voting, and being met by mobs of officers who attacked these individuals who walked across the Pettus Bridge. And so that's the image that many people recognize of the Jim Crow era. And many people may not know another horrific overlap of that space, which was racially offensive, called yellow peril. That is this idea that somehow the United States would be polluted by individuals who came from Asian communities. Now, of course, as with all variants of racism, there is a bit of irony to this, which is that the United States was actively trying to recruit, on one hand, Asian men to come to the United States as they were needed for work in the West, to lay the tracks for railroads, to blow up hills and mountain passes so that the work to construct the railway lines could take place. But yet within the same period of time, there were bans on the immigration of Asian women. And this was perceived as Asian women coming to the United States as a form of vice. And even with Asian men coming into the United States, there were concerns, these concerns that somehow they would render the health of white women somehow not stable, that these would be people who would spread drugs throughout the United States, that they would be responsible for drug addiction in the United States. This is a period of time in which there's very limited attention amongst a broader social discourse about the very blatant and very consistent through movies, through books, through pamphlets, putting forth these stereotypes and stigmas that were really quite harmful. Cartoons that were published in newspapers on the West Coast that dramatized the features of Asian men, and that some that would have these kind of lurid images of white women in the background, the perception that somehow they had become drug addicted, kind of infected by the vices of Asian men. The PAGE Act itself, an anti-immigration platform, very specifically spoke to the ways in which it was perceived that Asian women would be a threat in the United States. And of course, it's also very interesting when we think about this within the context of Jim Crow too, right? You know, as I said, the level of the kind of hypocrisy here that we don't want you, we want you. We want you as labor, but we don't want you as full human beings with full personhood and full human rights. This is a legacy that goes back to our nation's founding. And so how can we really talk about civil liberties and civil rights without also level setting about indigenous communities in the United States that were pushed out of their lands and that suffered health crises themselves by the various diseases that were brought over by Europeans who came to settle in the United States. But let's think about Ellis Island for a moment. We romanticize it today as the place where people's great-grandparents, great-great-grandparents came through. But Ellis Island and Angel Island, which is almost never discussed, were quarantine stations. These spaces where we could scrutinize whether there were some people who were worthy of gaining admittance in the United States. The idea that we were trying to sort of police people who could bring disease into the country. Now, some of you might say, well, wouldn't that make sense, at least to monitor those kinds of things? And here's the thing about this period of time, the 1920s and 30s in the United States and 10s in the United States. The perception was that the people who spread disease are people who are poor. Not the idea that people can become vulnerable to disease and infection and spread it if they happen to be wealthy. And this, in fact, brings me to something, a conversation that we've been kind of long in the pathways of having, but are only now really having it in robust and meaningful ways, save at the end of slavery. And that is to actually talk about white supremacy. It's an uncomfortable topic. It's been an uncomfortable topic for a very long time. But here's how it relates to the topic of today. Is actually through platforms of white supremacy that were imposed upon other white people. Like the very origins of white supremacy were not just about harms being imposed against people of color. The early eugenics platforms in the United States were about targeting poor white people. And in fact, if you think about it even longer, and it's not the subject of my talk, but come back for more and we can talk about this. The first efforts to combat voter suppression in the United States were amongst white men who were not propertied, wealthy people who wanted the right to vote. And so when I mentioned white supremacy in this talk, and I connect it to eugenics, and this question about who are the people who infect society, who are the people that are somehow genetically unfit, such that the health of a nation is risked by their very existence or their very ability to reproduce. And so as part of this level setting and thinking about where we are today is to also think about our history. And here I want to remind us of two cases that help us to level set with thinking about white supremacy imposed against other white people. How about that? The first case is a case called Buck v. Bell that, interestingly enough, has never been overturned. Buck v. Bell is a 1927 case that went before the United States Supreme Court. In this case, it involved a 16-year-old girl, poor white girl from Virginia, who had been raped by her employer's nephew. Now, it's an interesting side note of a fact in this case because the people that employed her were also supposedly her guardians too. Carrie became pregnant as a result of this sexual assault and rape. She was not married, so this would be a birth out of wedlock. The state of Virginia had engaged in a practice by this time of literally rounding up the people that it perceived to be genetically unfit in its society, genetically, morally unfit kinds of people. The perception was that this was an infection itself that could spread. The very existence of these people and the potential of these people to reproduce was perceived as a threat to the state's well-being. Now, to be clear, Virginia was not the first state at all to engage in a eugenics practice. It was Indiana, which was the first state to adopt a eugenics law, which provided for it to be able to incarcerate people that it perceived as being genetically inferior who could pollute the broader population. And so Virginia, 20 years later, has a model law. Now, for the law students who are watching this, you will know that a model law is such, it's a kind of model that any state, the idea is that other states will pick it up, that we've been able to shape a law which is adoptable, that can be universalized across many different states. Well, by the time of 1927, we're no longer Indiana, 1906. And so whatever the concerns were, whatever needed to be shaped into a model law, this was it. And the idea was to make sure that this law could spread, almost like the disease that Virginia lawmakers claimed that they were concerned about. And what this law provided for was the compulsory sterilization of individuals who were perceived as unfit. In Carrie's case, it was a test case. And what does that mean? It means that the lawyer who represented Carrie was actually a eugenics sympathizer himself. This was not about defending Carrie's civil liberties, civil rights, her autonomy, or about who she was as a constitutional person, how the Bill of Rights might have pertained to her, how the 14th Amendment might have pertained to her. That wasn't what this was about. This was making sure that there could be a win, that a state like Virginia would be able to have its law go into effect and sanctioned essentially by the United States Supreme Court. And they got their wish. In a ruling where there was one dissent, but one that is not on record, Justice Oliver Wendell Holmes, who was the Chief Justice of the Supreme Court at the time, he claimed that 3 generations of imbeciles were enough. He said that better than to let degenerate, that's his terminology, offspring, rather than to let degenerate offspring starve, or for degenerate offspring to engage in crime sprees, that society was better off by not allowing them to reproduce. He claimed that the power that a state had to impose inoculation was broad enough to cover cutting the fallopian tubes. And with this case, it ushered in tens of thousands of instances of cases of individuals being sterilized against their will. It's a case that was never overturned. There came a certain period of time in which lawmakers in the United States later said that the Germans were beating the United States at their own game. And you might wonder, what is the connection to Germany? Well, it was this model Virginia law that once the stamp of approval came by the United States Supreme Court, Germany adopted this law. It's eugenics law. We saw how that played out against individuals that were Jewish, that were from minority religious communities, against people who were LGBTQ, and so forth. But until the time in which the United States invested itself in World War II, there were politicians as well as medical officials in the United States that participated in ways that were horrific and chilling, are horrific and chilling to recognize today, and that were by their very practices. Tens of thousands of people were sterilized against their will. The coming attractions at movie theaters explicitly involve the advertisements of, here are how many hundreds of people that have been sterilized in the last month in Virginia, or in fill in the state, because there were nearly 3 dozen states that did, in fact, 3 dozen, more than 3 dozen states that did enact some versions of a eugenics law. And in fact, when you think about, for any of you who are watching who come from Midwest states and you're used to your summer fairs, right? These state fairs where, you can find even a fried Snicker on a popsicle handle, right? Years ago, there were fitter family contests. So today, when people go to see what is the fittest sheep or the fittest cow or the fittest horse, a century ago, there were people in the United States who were participating in events for the fitter family, the fittest family, looking to have their children pinned with a badge, having the bluest eye and the blondest hair. These are aspects of our history that are essentially lost to so many. Many of my law students are not aware of this. Later, the Supreme Court had an opportunity to intervene on its record and, in fact, overturn its record. It chose not to do so. And I should tell you, and I will with this next case, that the Supreme Court actually cited to a famous case from 1905, Jacobson v. Massachusetts, to render its decision in Buck v. Bell. Jacobson v. Massachusetts, this 1905 case, upheld the idea. It was more than an idea. It was a law in Massachusetts that provided for compulsory sterilization The idea was to tamp down vaccination. I hope I said compulsory vaccination, not sterilization. The idea was that in order to address the spread of smallpox, what was needed was inoculation, and that we should have herd immunity. And what this Massachusetts law provided for was an opt-out that came with a fine. So you could choose not to be vaccinated, but you had to pay a fine. The Supreme Court upheld the law, recognizing that the state of Massachusetts and local communities have what's called police power or parens patriae authority. That is, in order to protect the health and safety of a community, then a state may enact regulations, laws, et cetera, that will allow for protecting a community during a time of a health crisis. And this 1905 case, Jacobson v. Massachusetts, has served as the foundational case for over a century in addressing matters of health and safety. So instances like what we find today, Jacobson v. Massachusetts is a case that the Supreme Court cites to. Dean Erwin Chemerinsky and I write about the Supreme Court needing to develop a more nuanced jurisprudence such that we are able to mediate in ways where states and communities don't exceed authority, but where they respond to very specific instances. All right, that said, I want to tell you about another case, and this is Skinner v. Oklahoma. It comes more than a decade after Buck v. Bell. The Supreme Court declines the opportunity to actually overturn Buck v. Bell, but it's an interesting case that again speaks to the idea of intervening, harming people's civil liberties, encroaching on civil liberties and civil rights during what's perceived as some form of a crisis or threat. And so it's a eugenics era law that is what Oklahoma has. And this law pertains to people who are thieves. The idea being that somehow it is genetically linked, someone's thievery. And the law provides that people who are thieves can be compulsorily sterilized in prisons and jails in Oklahoma. The law, however, provides a carve out in that it only applies to petty thieves. It does not apply explicitly within the law. It's stated that it does not apply to people who are white collar criminals. So those people who might affect thousands, or maybe hundreds, not hundreds or thousands or tens of thousands of people's pension plans, or who might affect their savings in banks, etc., are exempt from this crime, or exempt from, not the crime itself, exempt from this extra legal type of punishment, this compulsory sterilization. And so the Supreme Court there overturns the law. The Supreme Court cites the 14th Amendment and its equal protection clause, that the law is not applied equally between categories of thieves, right? And it's an important case because the person who brought the case was a person who was a petty thief. He had stolen chickens, right? And so even though that was an opportunity for the Supreme Court to overturn its decision in Buck v. Bell, it did not do so. And that's worth noting because the concerns of Buck v. Bell continue to exist. So let me just make a side note here for a moment. I mentioned already that there were tens of thousands of sterilizations in the wake of Buck v. Bell. That's true, at least 60,000 of them associated with the legacy of that case. But there's another way in which these cases of compulsory sterilization surfaced in the United States, given that very backdrop, right? When the Supreme Court speaks to an issue, it allows a wide use or interpretation sometimes of what that case does, or if there's precedential value that is found there, you may find that states expound upon what the Supreme Court has provided for. Years later, Fannie Lou Hamer, that amazing civil rights warrior who fought so hard for voting rights, used the term Mississippi appendectomy. The Mississippi appendectomy, meaning that poor Black girls in the American South in the 1940s, after World War II, 50s and 60s, were being sterilized against their will. And what it was called was the Mississippi appendectomy. Parents bringing their children in for a medical consult, flu, cold, whatever that was, and their daughters coming back the next day, not even realizing that their reproductive capacities have been robbed from them. This is part of the origin story, or why it's so important to tell origin stories. All right, so let's level set again. That gives you some backdrop, and the backdrop is important. I'm going to give you one last stage of backdrop, and then we'll talk about COVID-19 and what this means in current times. When you sort of think about how police power authority can be abused, I spoke about that being abused against Asian American community within a culture of stereotyping and stigmatizing, with this sort of notion of yellow peril we must watch out for. We must use Angel Island as a quarantine station to police Asians coming into the United States because they may spread disease, either that which involves physical health or moral health. But at the same time, during Jim Crow, didn't we have this with water fountains, bathrooms, and swimming pools? Now, some may argue this was just blatant racism, and it had nothing to do with the perception that Black people were diseased. But there's a very long history of writing about this. And of course, there's also the hypocrisy too, because this is a Jim Crow iteration. It's not a iteration that we see during the antebellum times. It becomes a kind of convenient way of thinking about Black Americans once they've been freed from the shackles of human kidnap and bondage, which is to say that there is something wrong with them intellectually, morally, physically, and that one can't come too close to this, because if one does, it can render harm in a community. We see the image of this with the policing of swimming pools. Throughout the American South, Black people were banned from being able to swim in swimming pools with white people. And one of the ways in which Southern communities were complying with separate but equal laws, this idea being that Black people aren't being discriminated against for any racial reason. Instead, what it is that Black people get the equal thing to white people, right? And so the way in which that panned out during Jim Crow was that basically there would be one day a week, or one day of 2 weeks, or one day of a month that Black people would be entitled to swim in a pool. But how we know that there were these lingering concerns about Black people being pollutants in Southern societies is that those pools would be drained the night after Black people swam, and then refilled for white people's enjoyment. There is an iconic photograph of young people trying to protest such practices. And it's an image of a young Black woman having acid poured on her in a swimming pool while she is swimming with white peers. And so it's really important for us to understand both the social, cultural, and also legal phenomenon that have attended how we think about health crisis. And so where have we been now? Well, now we're in a space of COVID-19. And in the space of COVID-19, I just talked about compulsory sterilization, and this has surfaced during this time. Women in immigrant detention centers who have been documented to have been coercively sterilized against their will or without their complete knowledge of what was going on with them. A whistleblower, Don Wooten, has exposed this in at least one American detention center. For those of you who are in California right now, there are efforts to provide reparations for women who've been incarcerated in the state of California, who also experienced, not 100 years ago, not 90 years ago, not 75 years ago, within the last 10 years or so, coercive sterilizations. And so now we are within this period of COVID-19, and I've been concerned about what this means in terms of civil liberties and civil rights and how we balance making sure that we promote and protect health, which is really important, and balancing that against civil liberties. And so this is not an alarmist talk. Actually, the science does show we need to mask up. People, we need to be very careful during COVID-19. And when states, their governors, their legislatures have responded to the medical evidence, the epidemiological evidence that has been provided, that has been clear through the World Health Organization, through scientists who've been studying coronaviruses for decades. It's not new. Coronaviruses have been known for a long time. The medical science is irrefutable in terms of how coronaviruses spread, and this particular coronavirus spreads. And so when we think about how legislators, how governors do a good job, do the job that we want them to do, we want them to lean into medical science as they are determining what are the best approaches to keep communities safe. We want them to follow the evidence. But in addition to following the evidence, we want their actions to be tailored to that specific evidence and what it is that they are trying to achieve. That is to say that during a period of coronavirus, if a governor said, mask up because we have to be concerned and watch out for the spread of a deadly virus, well, an objective, clear, strong argument can be made for that. If a governor, on the other hand, said, well, to protect you from coronavirus, we must round up all girls aged 13 through 18 and make sure they're sterilized, well, then that is not actually following constitutional authority. That would be infringing upon civil liberties and civil rights. That would not be tailoring the response to the coronavirus in a way that protects civil liberties and civil rights. What we want is a balancing of both. And what we've seen in the wake of this coronavirus has been a challenging and in some instances a horrific type of mishmash. What am I talking about? The death toll associated with the novel coronavirus, otherwise known as COVID-19, even in its earliest months, surpassed over 100,000 American deaths. That was really quick. That was just in the first couple of months in the United States. And to place just that level of suffering in context, more Americans by the second month of COVID had died during that period of time than all the American deaths that were suffered in the Vietnam War. Right? The fatalities due to 9/11 terrorist attacks, the wars in Iraq and Afghanistan, and even the deaths of H1N1, Ebola, and the Zika virus. If you add all of that together, Vietnam, Afghanistan, Iraq, H1N1, Ebola, and Zika, by our first 3 months of experiencing the coronavirus, we had surpassed all of the deaths that were associated with that. In 3 months, its first 3 months, COVID-19 killed more Americans than what Americans had witnessed in the past 50 years of war and disease combined. Over the space of 19 years, which was the US involvement in Vietnam, there were roughly 59,000 deaths. That's over 19 years. We well surpassed that in just a couple of months of COVID. And so the chilling number of American deaths that span nearly 2 decades of Vietnam really paled in comparison to the deaths that were caused by this deadly virus. In essence, COVID-19 took barely 2 months to surpass the deaths suffered by Americans in over 19 years of the Vietnam War. And so what that staggering death toll brings to light are two interrelated matters. First, expose questions related to capacity, compassion, and competency in American leadership, federal government to local officials. The failure to heed international warnings and develop effective test kits in December of 2019 and January of 2020 highlighted very serious weaknesses in pandemic preparedness and American leadership. Hasty and imprudent political rhetoric in February and March of 2020, comparing COVID-19 to the seasonal flu, was not only inaccurate, but it was misguided. It likely contributed to a sense of false security amongst Americans who came to believe the virus was no more infectious and no greater a threat than the seasonal flu. And sadly, this view persists among some Americans, and perhaps not in the current administration, but certainly we saw a lot of that in the last administration, and we have seen that in Congress, despite the fact that we now have more than 500,000 people who have died from this coronavirus. And secondly, fundamental questions of constitutional law have also emerged. And let me just take a moment here to acknowledge people who have been our essential care workers. So many of these people outside of doctors have been working class Americans, some middle class Americans, but the people who are the tellers and the cashiers and the orderlies and the receptionists and the people who work at the meat packing plant and the people who are still doing the farming, the people who are considered essential but have been treated as if they are dispensable, disposable, not as if they are indispensable. Within a period of COVID, we also saw the death, the very tragic death of Breonna Taylor, who was also an essential care worker. But I want to be mindful of those who are watching, who have loved ones, who are essential care workers, who worry about their health and safety, and who hope that they get vaccinated soon. I too hope they get vaccinated soon. And many, many have in the space of this current administration. But still, there are many who haven't, including people who are working at meat packing plants. And so additional questions with regard to constitutional law, as I've mentioned, have emerged. And the coronavirus crisis has brought to the forefront a national debate related to the interaction between constitutional rights, state police powers, and also federalism. What are the limits of government action in the midst of a pandemic? And we saw tussling taking place with this, even in the space of the pandemic related to voting. One of the matters that you all may remember was the tussling in the state of Wisconsin about whether votes could be counted beyond the deadline because the coronavirus was spreading. There were people who had mailed in their ballots, but the ballots were still being processed and couldn't be processed in any more of a timely manner than they were. There were concerns that were raised in that state about people standing in line to vote, which is a fundamental right, but doing that during COVID, and the governor in that state trying to work with the legislature to make sure that there would be opportunities for people to be able to vote with safety. And we saw a tussle in the Supreme Court, and one of the last dissents, amongst the last dissents, of Justice Ruth Bader Ginsburg, who wrote a dissent criticizing the majority in a case, saying that what had happened in Wisconsin was that people were put in an absolutely awful position, either lose their right to vote, something that is fundamental, or to risk their lives by going to vote because the majority of the Supreme Court had sided with the Republican Party of the state that didn't want to make accommodations for voting during a pandemic, at least of the kind that the governor was trying to articulate for. So certain basic constitutional law questions have persisted. As I've mentioned, do governors have the authority to issue executive orders to shelter in place or to quarantine? Can the legislature prioritize some business activities as essential while not granting that status to others? We saw that casinos could stay open while places of worship were supposed to close. And we saw the Supreme Court taking up those issues. Is it legal to impose shelter in place on Sundays, a day when many Americans seek to worship, but not all Americans seek to worship on Sundays at all? And the short answer to some of those questions is that for nearly 3 centuries, quarantine has been justified and legally upheld. Even before, and that is quarantine laws, even before the official founding of the United States, dating all the way back to 1738, was the sense that government could protect its people during time of outbreak, including, if necessary, quarantining people so that there would not be the spread of disease. Now, of course, this is again why you want medical science and evidence to support what it is that a government is trying to do, because we don't want government saying that you must be in your home because we're protecting you from a disease when the disease may not exist, when there may be an effort to just simply target a particular group in society because they are vulnerable, they are unpopular. And that is what we want to guard against. That's what I talked with you about at the beginning of this talk. In an 1824 case, Gibbons v. Ogden, the Supreme Court specifically referenced state authority to regulate health and erect quarantine laws. 80 years later, in a seminal decision that I mentioned to you, the Supreme Court spoke directly to state police power to protect public health in its 1905 ruling in Jacobson v. Massachusetts. And as I mentioned, in that case, the court upheld an ordinance requiring compulsory vaccination of all persons fit for inoculation. The court found the statute to be a valid exercise of local police power to protect public health and reduce the spread of smallpox, a deadly disease. Now, let me just take a brief moment to say, for those of you who have questions, this is a time to begin putting them in the Q&A chat box so that I can get to them when I begin wrapping up. And so despite the myriad rallies and protests that we saw during 2020 over the summer to reopen, some filled with vile and violent imagery, including effigies of government officials, governmental authority to impose the types of orders that were modeled in California by Governor Gavin Newsom and in Michigan by Governor Gretchen Whitmer, or in New York by Governor Andrew Cuomo. Those were consistent with constitutional law, even though the court has done a bit of, the Supreme Court has done a bit of flip-flopping with regard to its docket in these cases. In other words, during a pandemic, some constitutional rights may actually be burdened, but only to protect the health of the public and to promote safety. Now, I want to be clear that government authority is not absolute at any particular given time, and that's important to keep in mind during a pandemic and times of pandemic. In fact, during times of national disaster and health crises, governments may attempt to exercise unconstitutional authority or unfairly or excessively infringe on the civil rights and civil liberties of individuals. We actually saw this in the case of a nurse who returned from the continent of Africa after helping with Ebola cases. She had tested negative for Ebola. She did not have Ebola, and yet the governor of Maine at the time imposed a quarantine order on her and also restricted her restricted individuals from coming into any close contact with her, prohibited where she could go to, how she could sort of move about. Now, that was unconstitutional. She did not have Ebola. She had tested more than once negatively for Ebola, right? And so actions such as that do infringe upon civil liberties and civil rights. And so what do we know? We know that historically, governments, including our own, have deployed protecting the public health as a justification when seeking to harm and undermine the civil liberties of vulnerable groups. From eugenics involving the forced sterilization of people who were socioeconomically vulnerable, and who were girls as young as 10 and 11 years old, to racial discrimination involving water fountains, swimming pools, and even interracial marriages. Politicians have oftentimes claimed to be in the service of public health goals when actually serving no other purpose than perpetuating social and racial stereotypes and discrimination. And so that's my level setting with you in this particular conversation. And let me just add one other piece to this, because I did mention marriage. In a case that went before the United States Supreme Court in 1967, so we are 4 decades after Buck v. Bell, the United States Supreme Court level sets. I've been using that word a lot because we need a lot of level setting against anti-miscegenation laws. There were laws that had been enacted throughout the United States that banned interracial marriage, and the justifications were rooted in protecting the public health. In fact, in that case, the state of Virginia has been mentioned a bit in this particular talk, actually argued in support of its race-based law, saying that it affected white people and Black people equally. White people couldn't marry Black people and Black people couldn't marry white people. The idea is that they would have degenerate offspring, that they would have offspring that could be experience disabilities, that they would have offspring that would be genetically inferior. And the state of Virginia and similarly situated states had to protect its communities from what could genetically result from interracial marriages. And so it's in that case that Virginia claimed it was a public health crisis that it needed to guard against. That is, being guarded against being swamped by children, men and women it considered to be unfit. All right, with that said, let's turn to Q&A and provide the opportunity for you all to register some questions. And we've got a couple of them here, and I encourage you to put more in the Q&A. So there is a question. Nearly half voters voted for President Trump. How do we get them aligned with reality? What can courts do? What can anyone do? Will Biden-Harris be a fix for this? Well, that is quite a question. I'll tell you that Dean Erwin Chemerinsky and I have an article that is forthcoming in the Pennsylvania Law Review that addresses the Trump administration and its handling of the coronavirus, and specifically its anti-immigration platforms and what that meant during the time of the coronavirus, both in terms of the suffering that was experienced by Asian American and Asian American Pacific Islander communities, and also by Latinx communities as well. To be clear, civil liberties are important to be guarded for and about, no matter who's in the White House, right? And so a Biden-Harris administration should be held to a standard a constitutional standard. The Constitution applied to all people who are in the White House. Now, what Biden and Harris have done has been incredibly promising with regard to both COVID-19 and also the respectful handling of these kinds of where we are with regard to vulnerable communities. It's been very, it's been very, very different. There hasn't been the mocking of communities. There has been the staffing of teams to address COVID-19. We simply didn't have that. We didn't have staffs of people who were on full time addressing the coronavirus during the last administration. We just simply didn't. We did lose essential time because of that. There are people who worked within the last administration who are speaking to that now, who've said that tens of thousands, if not hundreds of thousands of people, lives could have been saved. And so the question with regard to how do we educate people? Well, we're in a time now that's complicated with regard to how people understand facts. But to some degree, what I've also spoken to is a historical arc of people struggling with facts. And I spoke to white supremacy against poor white people. Again, a time in which there is the kind of weaponization against poverty and the stereotyping of people for no other reason that their socioeconomic vulnerability, that somehow that is genetically inscribed and that those people need to be wiped away from society. So in some ways, the kind of educating that we need to do has its origin story from some time ago. And I appreciate the question because we have to do a better job of it, greater transparency, greater clarity in dealing with some of our historical plot lines. All right, another question. Do you believe that public schools and universities have the right to mandate COVID vaccines for students despite the fact that it is not yet FDA approved? So, there are concerns with regard to the return to school and how institutions will manage. And it is a very tough thing right now as institutions are thinking about, well, how to bring back people safely into schools. Here's what we know. We know that there is a very high efficacy rate of at least two of the vaccines that people are taking, both Pfizer and Moderna. And we know that there's also a strong efficacy rate as well amongst the Johnson & Johnson vaccine, though not as high as Moderna and also Pfizer with the data that we currently have. We understand through the Centers for Disease Control, epidemiologists, and many other scientists who've been involved in the research with these vaccines, that they are safe for use. And we understand also that we are saving people's lives when we get vaccinated as a general matter because we achieve herd immunity. And so I think I'm not avoiding your question, but I am saying this, that with that data in mind, it is important for people to be vaccinated. And students want to return to school, and students want to be, they want to be in person. Now, there are some things that aren't quite settled, right? So what we do know is that there's a very long history of schools being able to impose standards of vaccination. That's not new, right? The Supreme Court courts have upheld that, and we see that through Jacobson v Massachusetts. So that is not new, right? In fact, the conditioning of students, K through 12 public schools, being able to go to a public school, it being conditioned on being inoculated and showing proof of inoculation has been upheld by courts. So that part is actually not new, and it's probably important to actually surface that. So thank you for your question. All right, we have another question, which is, could a government ever justify population controls to combat overpopulation, resource scarcity, or excessive pollution? So governments, here's an answer to your question. Whether it's legal or not, governments may, in fact, try to justify doing any particular kind of platform for a reason that it believes to be in the best interest of its community. There was a doctor's trial that was part of Nuremberg. So many people think of the trial involving guards and Nazi officials, but there was actually a separate trial, which was the doctor's trial. It's interesting to note that one of the chief defenses amongst these doctors was to say, we're doing what you did in the United States. Now, clearly they went beyond what was happening in the United States, but that was a defense that was made. But other defenses were that what the doctors in Nazi Germany were engaged in were consistent with protecting their military and also protecting their community. Now, that didn't stop the prosecution or doctors being found to be guilty. Now, have there been communities that have worked out family planning programs in order to address matters of sustainability? There have been, and there have been long conversations, including in the United States and in the United States Congress, related to aid provided to other nations. Exactly how do we address sustainability globally? And some of these conversations have been quite fraught. On the other hand, there have been conversations where people have been able to lead them in communities and to decide what is important for themselves in terms of family planning, right? And so there is a distinction between providing for family planning for communities that say, well, we want birth control. We want healthy, safe, effective birth control. And we want this to be accessible, and that it's unsustainable to have 10 or 13 children just in terms of a woman's health. That's a different conversation than one of government saying we'll impose these conditions on you. All right, there's another question. Do you think that we may see an order for compulsory COVID-19 vaccinations like we have seen in the past? Or do you think that the political landscape won't allow it? My sense is that we're not there with the compulsory COVID-19 vaccinations. I don't see that taking place anytime soon, though I leave the question open as matters will begin to be sorted out in the coming academic year and afterwards. These issues may shift a bit because, as I've mentioned before, basic inoculation has been upheld as legal as a condition of students being able to attend school. What might this mean in different stages? Perhaps nothing with regard to children that are in elementary school. Maybe nothing with regard to kids who are in middle school, or maybe nothing involving kids who are in high school. Or on the other hand, depending upon what data and evidence that we have in terms of risk of health of individuals who are in high school, who knows where we might be in terms of that conversation that engages epidemiology along with civil liberties and civil rights, right? The first chief idea is to protect individuals and make sure that they can be as safe as possible, while also making sure that we don't infringe unnecessarily on their rights. Good question there. All right, another question here. Several states, Texas, Mississippi, have reversed mask mandates against the advice of medical experts. Can the federal government mandate mask use as a public health necessity? Well, what a great question from a great friend who put that in the chat, who's a former vice chancellor here at UCI. Well, Congress could try to enact some form of a mandate in order to protect public health and safety. It would have to get through the House and also the Senate and then be signed into law by the president. The very challenge that we see with this backdrop is trying to get anything through successfully through both the House and the Senate. That is a real challenge right now. Right now, it's a Senate that has a Democratic tiebreaker through the Vice President, Kamala Harris, who's our former state's Attorney General and also Senator from this state. But what makes it a challenge theoretically, that could be possible. Pragmatically, will it occur? Very unlikely. Would it be challenged? Absolutely, is the way that I would answer that question. All right, let me go on to some other questions here. It seems from the history of cases that you've described today that there has been a slow evolution against laws that would hide improper discriminatory intent in a cloak of public healthcare protection. Do you anticipate that given its current makeup that the United States Supreme Court will tend to reverse this trend in any manner? Also, what a great question. I could spend a lot of time with you all putting questions in the Q&A box here. We are in a time of such great division in the Supreme Court, and a division that is beyond ideological difference. Even within the Supreme Court, Justice Sotomayor has called out the court as leaning into partisanship. The divide is that there are 6 conservatives on the court, 3 liberals. Justice Roberts has been perceived recently as possibly a swing vote. Justice Kennedy had been perceived as a swing vote. I think that actually overstates the role and work of Justice Kennedy. He was less of a swing vote when it related to matters involving sex equality for women. He was absolutely extraordinary when it came to writing opinions that advanced the civil liberties and civil rights of LGBTQ folks. And so where this court stands today, this is a court where, one might not use the term hostile to race equality, but a court that has not expressed a vision for racial equality and recognizing that racism still exists in the United States to such a degree that it can significantly harm fundamental rights. It was Chief Justice John Roberts in Shelby County v. Holder, a case that struck down part of the protections provided in the Voting Rights Act of 1965. And the Chief Justice basically said, we're in a colorblind state in the United States today. The kinds of discriminatory types of harms that we had to worry about during the Jim Crow era involving voting, we no longer have to worry about. It's hard to reconcile that opinion with the kind of voter suppression that we've seen in the United States over at least the last decade. And it's hard to reconcile that opinion with what we see coming out of Georgia. Because to be clear, with what we see coming out of Georgia, that you can't provide any food or water to a person who's standing in line to vote, that would seemingly be meaningless if standing in line to vote meant only 1 minute or 2 minutes. And even then I would have a problem with it. And this will be challenged and make its way to the Supreme Court. But when we keep in mind that factually, there are people who wait in line 5, 6, 7 hours to vote, and that these are individuals, some of whom have disabilities, that these are individuals who are elderly, and given that, and that no one could render them aid without the threat of arrest and violating the law is really stunning to me. And I think to many people who have weighed in on this. All right, next question. As people are coming forward, claiming that the Trump administration and the president intentionally and knowingly misled the public about COVID-19, resulting in 100,000 deaths and presumably many more infections, if proven, can these officials be tried and convicted of crimes against humanity? What an important question. The United States has basically seen itself as being exceptional. Now, here, what I mean is not exceptional as in great, although we have been a country that has leaned into the greatness behind science, health, and so much more, but exceptional as in it doesn't really have to follow and pay attention to what happens on the global stage. It can move in and out of that space. Hence, the United States being one of only a few countries that has not signed on to international protections, either for children or for women. And to be clear, we are talking about only a few countries. We're talking about countries that in this way we peer with countries that have put children into war, right? That's where we are with the countries that haven't signed international agreements for the protection of children. And so I answer in that way in terms of thinking about the United States availing itself to any international tribunals where, in fact, there could be some form of prosecution. So that's not going to happen. But what we have seen are gross tragedies. We have. And to be clear, it's not as if we have not seen local officials prosecuted when they have harmed the health of local communities, either through omission or commission. And we've seen that in the water crisis in Flint, Michigan, with prosecutions that are taking in investigations, indictments, prosecutions that are taking place in Flint, Michigan, with government officials who were aware of the risks that vulnerable communities were being exposed to. So thank you so much for that question too. All right, how has my experience during the pandemic affected my thoughts about job security in the law field during times like these? Well, I am very grateful for the work that I do. I am a professor at the University of California, Irvine. My chief faculty home is in the School of Law, but I have faculty appointments within our healthcare centers and also in Criminology, Law, and Society, as well as our Stem Cell Research Center and our Department for Gender and Sexuality Studies, and several other ones. So I engage quite broadly in my community here, and I'm grateful for it. What I will say is that I am deeply concerned about, and I have tenure, and I acknowledge that because there are people who teach and teach many, many classes who don't have tenure. And I want to acknowledge many people who are doing wonderful jobs as teachers across this country, and who are in vulnerable positions as they do so, were in vulnerable positions before COVID and are still in vulnerable positions during COVID. And I do want to do one more thing, which is to acknowledge the ways in which universities have been incredibly nimble, and students too, in leaning into these times and just simply doing their best. So I've approached COVID I've approached COVID in gratitude, quite honestly, which I think I try to do in my life generally. I am a granddaughter of the American South and the American North. And being a granddaughter of the American South, I had grandparents who came from legacies of experiencing the kinds of hardships that I wonder if any of us would be strong enough to endure. And so I approach every day that I live and am able to carry out my life, even during tough times of navigating this world as a Black woman, with a sense of gratitude for the work that they and so many other people did do so that I would have opportunities accorded to me so that I could flourish and blossom. So thank you very much for that question, because I'm also very mindful of people who live in much more vulnerable conditions. And then let's see, finally, is there one last one to address? One more question. Are there any precedents from the war on terror after 9/11 that apply to how government can restrict civil liberties due to pandemic Emergencies. Let me say there, it was found that the government acted in unconstitutional ways in the wake of 9/11 in doing searches, internet searches and other searches of individuals' data without warrant. And it was after that that Congress enacted laws that would provide for government being able to do some amount of that. But early on after 9/11, when the government engaged in acts of surveillance without warrant, that was illegal and unconstitutional. And with that, I see my colleague has returned to the screen. So Mary Ann Sodden, let me turn it over to you. Sodden, I appreciate you. And I think you're muted.
There we go. I regret that I'm the timekeeper, and our time is nearly up. So I did want to take a minute to thank you, Professor Goodwin, for your just remarkable presentation on civil liberties in history and in this pandemic era and looking to the future. I think there's so much for all of us to be thinking about and watching for in the courts and the legislatures, and you have both leveled us up and sent us with the challenge to look ahead. I also want to thank the audience for joining us tonight and for their really interesting questions. If you're someone who has requested continuing legal education, keep an eye out for your forms in the next week. And just know that we would really appreciate your evaluations and look forward to seeing you at more of the series. Our next presentation on law and policy in the Biden-Harris era is scheduled for May 20th, and it features our tax faculty speaking on the state of play in tax reform. So I hope you'll join us for that as well. And until then, thank you again, Professor Goodwin, and thank you all. And that wraps up our presentation tonight.
Thank you so much. And I want to thank our audience as well. You all are wonderful. Thank you for your questions.